Um, all right, so thank you again so much for the introduction. Perhaps take it over then from that Commissioner Dow.
Thank you very much, and thank you, Tandeka. Appreciate the introduction. Welcome to everyone to this launch of the Human Rights Commission's report on the overregulation of school uniform and appearances. The Human Rights Commission held an inquiry here in the Eastern Cape to address concerns regarding the alleged excessive regulation of learners' appearances and school uniforms. This was in response to certain complaints that we received, as well as various media reports pertaining to alleged discriminatory practices concerning learners' natural hair, religious symbols, cultural symbols, and requests for gender-neutral school uniforms. So the Commission has made certain key findings and analysis in this regard. In respect of the right to dignity, the Commission found, excuse me, the Commission found that school uniform and appearance policies can indeed infringe on learners' dignity in various ways, including by regulating their hair length, enforcing gender stereotypical uniforms, and treating appearance violations as disciplinary issues. Binary school uniforms may oppress individuality and limit self-expression. The cost of school uniforms can also be prohibitive, possibly leading to discrimination. Practices such as regulating girls' underwear are abhorrent and invade privacy, with no relation to the right to a basic education whatsoever. Those are our findings in respect of human dignity. With regard to the right to equality, the Commission found that enforcing binary school uniform policies may reinforce traditional gender norms and discriminate between boys, girls, and gender non-conforming learners. Such discrimination is considered unfair as it impairs human dignity. As far as the right to freedom of belief, religion, and opinion, and the right to culture and language are concerned, we found the following. Accommodations for learners to express their religions and cultures within compulsory school uniforms are crucial. The lack of a clear accommodation process may violate learners' rights. In respect of the right to freedom of expression, the Commission finds that the right to freedom of expression can be limited in certain circumstances, and that school uniform policies may be justified to limit self-expression if they are affordable, reasonable, and non-discriminatory. So we don't find that school uniforms are, in essence, and as a point of departure, a problem, but then it has to be affordable, reasonable, and non-discriminatory nature. As far as the best interest of the child is concerned, we find that the two-finger test on learners' bodies and monitoring the color of girls' underwear violates the Constitution's emphasis on the best interests of the child. These findings are far-reaching and have a broad application for all school uniform and appearance policies, regardless of whether they are in public or private schools. In terms of the recommendations of the Commission following the report and the findings we have made, we recommend in the first instance certain immediate reforms. The National Department of Basic Education must immediately abolish any hair policies that differentiate between male and female learners. There is no constitutional basis for that discrimination, and we do find that to be unfair discrimination in terms of our Constitution. This includes eliminating any practice that discourages or subjects African learners to disciplinary procedures for wearing afros, braids, or any other natural hairstyle chosen by the specific learner. All learners must be allowed to wear any item of clothing that forms part of the approved school uniform, regardless of their sex or gender identity. Gender-neutral uniform options must be provided to accommodate gender non-conforming learners. The practice of prescribing underwear for female learners must be eradicated and condemned, and learners and caregivers should be encouraged to report any invasive monitoring to law enforcement agencies for investigation. The Commission further recommends that within the next 6 months, the National Department of Basic Education and Provincial Departments of Education must conduct an audit of all school codes of conduct to determine whether they include deviation and accommodation processes that allow learners to express their culture, religion, and beliefs. The National Department of Basic Education must also conduct a baseline assessment to determine a cap on the costs of any basic school uniform, taking into consideration our country's socioeconomic circumstances. Furthermore, the National Department should consider issuing binding directives to provide for this minimum framework. The assessment should also consider whether the prescribed regulation uniforms are conducive to the South African demographic and best interests of the child. Factors to include in this assessment should involve an evaluation of whether school uniform materials and items are contributing to accessing basic education, or if a compulsory standard uniform that caters to the physical and socioeconomic needs of learners and their families is recommended based on current research. The National Department of Basic Education should make it clear that expensive clothing, such as blazers, is not compulsory. We also recommend amendments to the uniform guidelines. The National Department must amend the uniform guidelines to include the findings of this report and should consider binding directives instead of guidelines to prevent non-compliance. Within 8 months, the National Department and, where applicable, provincial education departments must provide the Commission with a report on how they have addressed or plans to address the above-mentioned directives and recommendations, the ones I've read out now, within 8 months after the issuing of this report. The report should include clear time frames and action items for each directive and recommendation. The Commission's inquiry emphasized the need for inclusive, rights-based school uniform and appearance policies in our education institutions in South Africa. Urgent reforms are essential to safeguard the fundamental rights of all learners. All stakeholders are encouraged to work collaboratively to create a conducive and respectful learning environment for all. This is quite a profound report with quite profound, which will have quite a profound effect. And we thank everyone who participated in the inquiry, everyone who assisted us in this whole process of eventually coming to what I think is a very progressive findings, recommendations, and directives from the South African Human Rights Commission that can indeed change the learning environment for learners quite substantively going forward. Thank you very much. Thank you. Over to you.
Thank you so much, Commissioner. I don't have anything to add at this stage. Sante.
Yes, this report and these findings are set to have far-reaching consequences for the environment of learning in South Africa and the culture of schools in the country. this is a historic moment in the history of basic education in the country, and it's likely to have far-reaching influence beyond the borders of this country, throughout Africa and beyond. I just wanted you, Professor Dr. Gam, and to explain how you came about and what was the process. I see here that this was a highly consultative process involving student organizations such as COSAS. It was highly participative. It involved the student communities like the governing bodies, as well as a number of stakeholders such as religious and traditional leaders. Could you explain this process and how consultative it was, and why it is that you sought to cast the net so wide in terms of democratic participation?
Yes, I think it seemed, and Eileen can also add on, but it seemed to us that there are huge problems with regard to matters concerning uniform, concerning appearances of learners. The Human Rights Commission received various complaints, are receiving various complaints about this across the country. We have had to intervene on various occasions where we came about issues pertaining to the wearing of natural hair. We had to intervene in various provinces with the education departments, with schools. And we thought that, these discriminatory practices and the impact it has on various rights, that we need to deal with it systemically and holistically. And in view of the fact that the Eastern Cape Province Provincial Office actually took the lead, and we are very, very happy that they have actually that they've done that. After they have also received various complaints, and all the media reports we see every now and again, we thought that this is a matter that the Commission should really look into as broadly as possible, and then come up with very clear findings, directives, and recommendations. And obviously, we wanted it to be as inclusive as possible, and therefore, to come back to your question, we have involved various stakeholders, even private school executive bodies, rental bodies, and so on and so forth, to come and testify, which they've done. We had the inquiry in Gqeberha, and then coming up with a very clear direction for the way forward. So, and once again, we do thank everyone that have actually participated. Eileen, I don't know if you want to add to that.
Commissioner, you have also been guided by legal precedent, and the Pillay case that made its way all the way to the Constitutional Court, and wherein the court found that preventing a student from wearing her nose ring stud infringed upon her religious and cultural identity. Now, this is significantly different from the findings of the constitutional courts and the authorities, educational authorities of different jurisdictions. For example, France recently banned the wearing of hijab or foulards. What are the constitutional principles that underpin our own jurisprudence on these issues, and how do they differ from those of other jurisdictions that have come to different findings?
Yes, now there is quite a stark difference, as you point out, between the findings that we have made and some of the practices in other countries. I think it is also, we can also, in that regard, be thankful that we have a very progressive constitution, and a constitution that is based on the important principle of unity in diversity. So it is expressly recognizing the importance of diversity, and we have various very specific rights that we have obviously applied the the facts of the complaints and so on we had. We have applied the law to those facts, the constitutional principles, the Bill of Rights, rights concerning human dignity, very specific rights pertaining to equality and what unfair discrimination is all about, as well as cultural, religious rights, and so on. In a sense, these findings and directives go a bit further than courts, in terms of deciding these kinds of matters. We make the interesting finding here, for example, that mere discrimination on the basis of the length of the hair of boys and girls, that is unfair discrimination, without having to bring in matters concerning cultural, religious rights, and so on. But that mere differentiation between boys and girls on the basis of the hair length is, in our view, unfair discrimination and should be removed. So you would actually find that the guidelines on school uniform and so forth, the national guidelines itself contains certain provisions that are, in our view, at odds with the Bill of Rights. And therefore, it is indeed quite important. For example, the binary approach there, only referring to boys and girls. It is therefore indeed necessary for the National Department also to make very specific amendments there, and we are saying it should go further than only being guidelines. They should consider making it binding directives of some sort.
No, absolutely. Van Dijk, I think the Constitutional Court has also been very clear. There's strength in diversity. We should not merely tolerate diversity. We must embrace diversity. And that is what the Human Rights Commission has come out very clearly to say. We should stop trying to force assimilation, a clearly diverse environment, to norms and standards that we feel very clearly as the Commission were important. So our position, I think the report is very strong on that. Diversity is certainly not a weakness. It is a strength of this country, and we need to embrace it. Siko Sonke has also very closely worked on the report. Siko, do you want to comment on that basis?
Yes, just to add on what my colleagues have said. We live in a very diverse country, so it is important that is reflected in every sphere of society. Education is paramount. It is protected in the Constitution as well. So we do need to have laws that speak specifically to that, not only accommodate diversity, but all groups need to be integrated for purposes of having a functioning society. Our laws, our policies need to be reflective of what we want to achieve, and also of our current constitutional dispensation. So it is important that we lean on the principles that are enshrined in the Constitution so that we can achieve diversity. So inquiries like this, they critically analyze those kind of issues and identify areas of improvement. So that's definitely what this inquiry spoke to and what the report speaks to currently.
Indeed, it does appear that the actions of the South African Human Rights Commission in engaging society on this matter very broadly and in coming up with recommendations and findings that are based on the Bill of Rights and the South African Constitution has a sort of made the Constitution a living document, and living particularly for children, schools, and very practically in a very distinct way made the rights of children center and stage, and particularly, we've got a jurisprudence of dignity, and that flows like a leitmotif throughout your findings. But I am interested in the fact that you have not only looked at the issues of identity, broaching the issues of gender identity, cultural expression, self-expression rights, as well as issues of religious tolerance and expression in schools. You've also looked at the socioeconomic dimension. particularly curious about what the private schools said about blazers, because we know the attachment to old school blazers. I have such attachments myself. And you finding that these emblematic dress or attire may not be socioeconomically sensitive to people.
Maybe I will start by saying, yes, we need to ask ourselves very clearly in the environment we live in at present and the socioeconomic circumstances we have here, whether it is really defensible to insist that all learners of schools have blazers and so on and wear blazers. Even given the climate that we have here in South Africa. And yeah, I'm sitting, for example, today without a tie, without a blazer, because in daily it's a hot day, but I'm just not in the mood to actually wear that. So why on this planet Earth do we still insist that in schools, in the name of neatness or whatever the case may be, or the glorification of that particular school, that we insist that learners have blazers? It's a very expensive item, and that's why we specifically include here that children should be optional.
So blazer optional.
It should be optional at best.
I am interested, Dr. Eileen, in what the University of Fort Hare, which is one of your most vocal participants, may have said. They have an Africa famous yellow, gold, and black blazer that is a symbol of almost African nationalism and tied to education. I'm interested in what they had to say about all of this.
You know what? We were very, the universities were very participatory. That's the nature of the same with Rhodes University. The memorandum of understanding we have with universities in this province is they participate because they're also experts in this field. But on this specific one, we need to go look at the right to basic education. We need to go have a look. What is the link between a school attire, the content of the material of the blazer, in an environment where we are mostly subjected to load shedding, where moms and caregivers are unable to go and iron, wash these garments on a regular basis because of a fear that their children will be subjected to disciplinary action. So we need to ask ourselves those questions, whether it's still relevant in our context, and whether the same aim of the right to basic education for our kids can be reached, as commissioners say, in a more comfortable way. We've done our tests, we've done our samples to know that there are a variety of schools who make use of easily obtainable clothing garments, which is not restrictive to kids and certainly is not distracting to kids and not at the level of what it is currently costing and a largely impoverished South African cohort to send their kids to school. So ours would be to find conducive manners in promoting access to basic education, to make sure our kids are encouraged to go and not prevented. And not, you would have seen from the evidence that we've received, children undergo anxiety attacks because of a fear that their hair might have reached the earlobe. Anxiety attacks because the caregiver was not able to wash or rinse the specific garment required for that day. And then we need to ask ourselves, are we serving to the best interests of the children of this country to continue on that trajectory? And the commission is of the view, well, we're not. And I think it's a good conversation we need to have. It is also a reflective conversation we need to have as South Africans, as an Afrocentric discourse, whether it's at all applicable and where it in actual fact comes from. So we've included a lot of research there. Unfortunately, the context in terms of the African discourse is limited. And that's an opportunity for us. We can have this discourse and we can create this context we can create the baseline for us to have these discussions as the Human Rights Commission with the assistance of our tertiary partners and communities at large, so that we promote access to basic education and not hinder kids from access.
I thought when you were about to respond, you would also mention that the South African Constitution is one of the few that mentions and gives guarantees of socio-economic rights. Do you think that these findings take the basic education system in South Africa closer to universal access? That it's a significant step towards universal access to education?
Yeah, we most certainly think so. It is making sure that there are no that there are not prohibitive factors in terms of learners' appearances and the uniform issues to make that access to education possible. Eileen made a very important point. One should ask yourself, this rule or regulation, whatever it might be, what is the relationship between this rule and the realization of the right to a basic education? And if there appears not really to be any relation, then you should ask, is this rule or regulation, whatever the case may be, really necessary? And I think that is a test we also apply to a very large extent here. But apart from that, obviously, some of the practices that we see in schools and in codes of conduct and so on are indeed impeding on rights instead of realizing or fostering rights in our Bill of Rights. So the Commission, and flowing from this, and I think that's quite an important point as well, the Commission has also agreed to a model code of conduct for schools, but we are further refining it and so on, also taking into account this report, and hope to publish that in the near future, which would be a model human rights compliant conduct code of conduct for schools. So I think that the report and that model code of conduct can really take things further in terms of accommodating instead of excluding, and therefore access is
Right. I see that the sections that the legal principles that you were emphasizing throughout the findings are the right to not only education, but the right to dignity, the right to equality, the right to freedom of expression, the right to freedom of culture and language, religious freedom, as well as the best interest of the child. You also looked at the different cultures as they pertain at the moment. So you've given a snapshot of South African schools as they are now. Now that's a very valuable picture to paint. And you've given us a vision of the future of a freer South African school culture. How do you think social exclusion, which you have sought to attack here, impacts on educational outcomes? Do you think that is important for parents to consider in when they weigh the weight of your findings?
I think we can circle it back to the diversity argument to say we in some instances South Africans have been sometimes conditioned to fear diversity instead of embracing it. And I think we would hope that this report encourages parents not to fear the diversity, not even diversity, self-expression of children. The fact that a girl child may want to wear a large afro should not be condemned, it should be encouraged. Not only in terms of culture, perhaps, or religion, but in terms of self-expression. The UNCRC and our regional documents in respect of children's rights are very clear. Child participation and child expression and the rights of the child to be heard We must embrace that. And we must give children also an opportunity to express themselves. Now, Commissioner has indicated that we must always still remain with how does this either impede or promote access to basic education. So surely if something takes away, we need to be regulating that. We need to make sure that there are clear parameters. But if it's not, like the wearing of an isipandla, surely we can promote that without taking away anything in terms of discipline, regulation, but we can promote self-expression through that. And that is just clearly in line with our constitution as well. So there might be a fear. Something different is always a challenge. Nobody really likes change. But luckily, we've got parameters so clearly set out for us in the Bill of Rights that we can just ascribe to them, it's there, and say that as the Human Rights Commission has done here, we've aligned ourselves clearly with the parameters that are already provided for us. Those are human rights baseline.
Are we not a bit late, Bisco? Because Zuleika Patel in Pretoria and her classmates and her girlfriends at the girls' school that they go to sounded the call in 2016. It's 2023 today. We're not a bit late. Have the kids and the parents not told the human rights community much earlier, and the authorities in our country much earlier, what they would like to see?
Certainly, there may have been instances, excuse me, where that has happened. However, I do not believe we can put a timeline to progress. It is a continual thing. It's something that is ever changing, especially when you look at current political climate. The law is forever changing. Similarly, in how we approach issues too, we should have the same approach. We should not put time limits and allow ourselves to grow with times. Our current society is very diverse, very open too. So it actually reveals an opportunity for us to take advantage of that in terms of allowing different different genders, different cultures. Also, our society is served enough of a blueprint for us to use that as a stepping stone. But we are not late. We can never be late, especially when we talk about realizing rights. It's a continuous growth. So that's the mindset that we need to approach so that we can also allow ourselves to go back and amend and change things that are not working. So we need to always approach things with an open mind and not put time limits.
It's iterative.
Yes, definitely.
Well, on behalf of Rhodes University and this educational community here in Makhanda, we would like to say that we welcome and continue to value and express gratitude to the Human Rights Commission for this collaborative effort that takes national basic education into the next century. On behalf of the School of Journalism and Media Studies, and on behalf of the Rhodes academic community, you are most welcome, and thank you very much.
So much.
Thank you so much, Sandeka. I think Zukiswa, I think without any questions online, open up. And Rhodes University, a partner in the realization of human rights, we thank you.
Thank you so much.